I'll try and be brief since my colleagues have covered. So one is on jurisdiction, my lord. So I think I'll take less time because it's been covered. And on jurisdiction, I wish to rely on the decision. Okay, thank you. I appreciate it. Yes. Thank you, my lord. I appreciate. So starting with the question of jurisdiction, which we have raised in our preliminary objection, my lord, I wish to refer you to civil application from the Court of Appeal in Nyeri, number E093 of 2023, Kawera Mwangaza versus the County Assembly of Meru. Civil application number E093 of 2023, Court of Appeal at Nyeri. Parties are Kawera Mwangaza versus County Assembly of Meru and the Speaker of Meru and the Speaker of Meru. My lord, in this matter, it's in our list of authorities at paragraph 22. The Court of Appeal found that they do not have jurisdiction. Oh, sorry, my lord, at paragraph 21. They do, yes, my lord. They do not have jurisdiction in the first instance to consider the merits of the application for conservatory orders before the impeachment process has run its constitutional and legal course. They downed their tools at that point because the matter was pending before the legislature. They then proceeded to say that Honorable Mwangaza still has an opportunity to appear before the Senate, and if she is impeached, she still has the right to approach the court for appropriate relief.
Until?
Sorry, my lord?
Until?
Oh, I'm saying, and after that, the court proceeds to say that if the petitioner, in this case, Honorable Mwangaza, is impeached, she still has the right to appear before the Senate. Okay, let me go back. This court lacks jurisdiction in the first instance to consider the merits of the applicant's application, which sought conservatory orders before the impeachment process has run its constitutional and legal course. They then proceed to say even runs its course, she still has a right to appear before the Senate, and she still has a right to approach the court for appropriate relief, yes. So at this point, the petitioner finds himself in the same circumstances as Honorable Mwangaza. He has produced the invitation from the Senate. He has produced the invitation from the Senate to provide his documents this evening by 5. He has produced an invitation to appear on the 16th and the 17th of October. My lord, the Senate is the impeachment court. That is the trial court. The petitioner has a right to appear there, present his evidence, rebut what the National Assembly has presented to the Senate, and it is only once that is concluded that he can seek to invoke the jurisdiction of this court. My lord, I also wish to rely on the Supreme Court decision of Karaoke Mate, which has been extensively cited this afternoon. Because if you exercise your jurisdiction and grant the orders that the petitioner is seeking, the effect will be to stop a constitutional process. And at paragraph 84 of the Karaoke Mate decision, The court said that no government, 84. The Supreme Court says no governmental agency should encumber another to stall the constitutional motions of the other. My Lord, the 10 days for the Senate are already running. If you issue a stay of those proceedings, it brings the constitutional process to a halt, or puts the Senate and the Speaker in a position where they have to decide whether to comply with Article 145 or to comply with decisions of the courts. And that was why Kariuki Mate had initially been convicted of contempt, because he was forced to choose between the two. My Lord, we ask that you allow the Senate to conclude and then give whatever appropriate reliefs. And at this point, my Lord, that is why the petitioners have been unable to demonstrate that their petition will be rendered nugatory if these orders are not granted. It will not. What they will do is to take the outcome of the decision in the Senate, which may even be in favor of the petitioner. He may or may not be removed. We do not know. And then approach this court for appropriate reliefs. At this point, nothing will be rendered nugatory if the Senate is allowed to proceed with its constitutional mandate. And my Lord, I wish to tie this to Gatirau Peter Munya's principle of public interest. The Supreme Court said